Good afternoon, and thank you for joining us for the third and final edition in our series of webinars focusing on biosimilars. So far, we have considered the basics of the regulatory system for biosimilar products in Europe and the US, looked at the way in which biosimilars are prescribed and how, within this framework, biosimilar manufacturers can access the market most effectively. Today, we're going to look at the pricing and reimbursement of biosimilars and at some competition challenges to marketing practices, particularly in the US. As with the previous webinar, these topics are regulated nationally. So again, we have a number of experts from different jurisdictions to guide us through the issues over the next hour or so. My name is Matthew Royal, and I am joined by Heather Schneider and Mike Johnson from Willkie Farr Gallagher, and by my Taylor Wessing colleagues Manja Epping from Germany, Evelyn Friedel from France, and Wim Maas from the Netherlands. To begin with, I'll hand over to Manja to explain the position on pricing and reimbursement in Germany.
Thank you, Matt, for this introduction. Pricing and reimbursement for biosimilars in Germany is not specifically regulated, but follows the general principles which are set out in the 5th book of the Social Code for the Statutory Health Insurance, or SHI. In Germany, nearly 90% of the population is health insured through the SHI. The remaining part is taking out health insurance from a private insurance company. As far as pricing is concerned, the list prices for medicinal products are determined by the marketing authorization holder. A separate pricing approval does not exist. However, German law regulating the statutory health insurance contains various mechanisms of cost containment, which include determining a maximum reimbursement price under certain circumstances. For medicinal products containing a new active substance, a mandatory benefit assessment procedure was introduced as of the 1st January 2011. In this procedure, pharmaceutical companies have to prove an added benefit of the new medicinal product as compared to the standard therapy, which is to be found in the process. Based on the outcome of this assessment, the top organization of the SHI and the pharmaceutical company concerned negotiate and determine the reimbursement price. However, biosimilars are exempt from this procedure as their active substance is not considered to be new, although it is not identical with the API of the original biological product. By contrast, biosimilars are subject to other cost containment measures provided for in the Social Code, including the following that are set out on the slide. Firstly, a mandatory rebate on the list price of the pharmaceutical company, which is 7% for medicinal products in general and 16% for patent-free products containing the same API. Most biosimilars are subject to the 7% rebate. The 16% rebate only applies to bioidenticals produced in the same manufacturing process and to biogenerics, which were authorized by reference to the preclinical and clinical dossier of the originator product without the need to present own studies. Secondly, they're subject to a price freeze, which means that any increases of the company's list price remain without effect on the reimbursement price to be paid by the SHI. The price freeze has been recently extended until the end of 2022. Since July 2018, yearly increases based on the Consumer Price Index have been permitted. Biosimilars can also be included in reference price groups. The products included in a reference price group are allocated the same maximum reimbursement price. In practice, this means that the company's list price will be lowered to match the reimbursement price. The maximum reimbursement price is regularly reviewed and often lowered, which results in a price decrease for the patent-free original product as well as for biosimilars of this product. My colleague Wim Maas will present in more detail a similar concept existing in the Netherlands. Biosimilars can also be the subject of rebate agreements with the SHI. This means that the product is sold at its list price, but a confidential rebate is agreed between the SHI and the pharmaceutical company for reimbursement. Most of the rebate agreements applicable to biosimilars are non-exclusive open house agreements, which are open to all products with the same API. The Association of Biosimilars Companies has repeatedly commented on the impact of cost control instruments of the SHI on the effective market access of biosimilars. Its recommendations include the following. First, in order to improve market access for biosimilars, regional agreements should be concluded between statutory health insurance and associations of physicians on the preferred prescription of biosimilars and target volumes. These agreements are intended to incentivize physicians to prescribe biosimilars and to avoid restitution claims by the SHI based on lack of cost efficiency. Secondly, to provide information to doctors about biosimilars, including pharmacological and price information, in order to convince them of the safety and efficacy of biosimilars and equally incentivize doctors to prescribe these products and to take advantage of the price difference. The association also recommends introducing reference price groups for biologics and biosimilars only when a grace period after market entry of the biosimilar has elapsed, because otherwise the market participants cannot take advantage of the lower price of the biosimilar as compared to the originator product. Furthermore, the association criticizes exclusive rebate agreements which are concluded between the statutory health insurance and the originator company shortly before patent expiry, as it happened before infliximab biosimilars became available. In such case, physicians are incentivized to prescribe the originator product even when less expensive biosimilars have entered the market. So, what is the situation for biosimilars on the German market today? We do indeed see an increasing number of agreements between the statutory health insurance and associations of physicians, which include target prescriptions quota for biosimilars. For example, the regional agreement for Saxonia for 2018 provides for a prescription quota of at least 37% of defined daily doses of EPO biosimilars in the area of nephrology and a prescription quota of at least 25.3% of defined daily doses of somatropin biosimilars in the area of pediatrics. In addition, the SHI, regulators and certain doctors' associations, for example oncologists, and self-regulated bodies have provided regulatory and scientific information on biosimilars that encourages doctors to prescribe biosimilars, especially when a new treatment is started, but also to consider a switch from the originator product to a biosimilar in the course of a therapy. That being said, the market share of biosimilars within the SHI still varies a lot among different types of products, as you can see at the bottom of the slide, ranging from less than 6% for insulin to 66% for filgrastim. Based on the spending of the SHI, the percentages based on defined daily doses are even somewhat higher. Various factors contribute to these differences. Amongst them, for example, long-standing market experience, the traditional reluctance of certain doctors' groups to prescribe biosimilars, as has been the case for pediatrists in relation to the growth hormone somatropin, the prevailing use of a product in the ambulatory sector, or rather in a hospital setting, and above all, the incentives or disincentives set by the statutory health insurance. I will now hand over to Matt again, who will give us an insight on the situation in the UK.
Thank you, Manja. There are two options to pricing and reimbursement in the UK. The first and most common regime is the Pharmaceutical Price Regulation Scheme, or PPRS, and the second is the Alternative Statutory Regime. The PPRS is a non-contractual agreement between the Department of Health and the Association of British Pharmaceutical Industry, or ABPI. Companies can voluntarily agree to be bound by the PPRS by submitting a form, and it's not actually necessary to be a member of the ABPI to do so. For this reason, as I mentioned, it is the most commonly applicable regime. Biosimilars, as branded products, are expressly covered by the PPRS. This has two implications for the pricing of biosimilars, which ultimately lead to discounts for the Department of Health. First, the NHS list price must be submitted to the Department of Health and agreed by them before launch. A decision on the proposed listing price will be made within 28 days, and so this needs to be built into any launch plans. If the price is not agreed by the Department of Health, there are dispute resolution procedures available under the PPRS. There are also various procedures available to vary the NHS list price to reflect value-based pricing and to amend the original list price. And this is because a product's value may not be fully appreciated when it is first listed, although these procedures are more likely to apply to new products rather than necessarily to biosimilars. The second implication is that the PPRS payment mechanism applies also to biosimilars. Without going into the detail about how the calculation works, this essentially means that up to 7.8% of biosimilar sales at the NHS list price will have to be paid back to the government. What will be clear is that both of these mechanisms lead to an effective discount for the NHS. Before moving on to the statutory scheme, it's important to note that the PPRS is renegotiated every 5 years and is next due to be renewed on the 1st of January 2019. This means that the current position is subject to change over the coming months. The alternative statutory regime applies to companies that have not agreed to use the PPRS. This scheme is currently being renewed to bring it into line with the PPRS. In particular, the intention behind the amendments to the statutory regime are to mirror the PPRS payment mechanism, and as such, it will apply to all biosimilars to ensure that savings are available. The Department of Health notes that smaller discounts of about 70% are available for biosimilars, and so it is important to the Department of Health that they are covered by the scheme. There is also a percentage of biosimilar sales paid back to the government in the same way as the PPRS payment mechanism. This will start at 7.8%, which is the current level, as I mentioned, under the PPRS, and will increase to 21.7% of sales by 2021. This statutory regime is going through a public consultation at the moment, which closed on the 18th of September. And so, as well as the changes due to the PPRS, this statutory regime may also be subject to change in the coming months. I'll now hand over to Evelyn to explain the position in France.
Thank you, Matt. So in France, the general reimbursement scheme applies to biosimilars. There is no specific regime for biosimilars. The company which markets and commercializes the biosimilar, being called qualified exploitant as defined by French law, must request its registration on the list of reimbursed products. And indeed, there is a difference between biosimilars and generics, because the latter benefit from an easier procedure. They do not need a prior examination by the National Authority for Health, the HAS, as this is the case for biosimilars. For biosimilars, the company must indeed submit a technical file, to the Transparency Commission of the National Authority for Health. This is the first step. The latter has then to assess the therapeutic value of the product, i.e. the medical service rendered by the product. Needless to say that, of course, this is quite close to the originator. Although the biosimilars cannot avoid going through the procedure before the National Authority for Health, they can in some instances benefit from a simplified procedure. So, the opinion of the Transparency Commission proposes a percentage of reimbursement, which is generally in the range of between 65% to 100%. This is just the range of reimbursement in light of the benefit which is granted by the medical product. So once The second step is as follows. Once the opinion of the National Authority for Health is rendered, the company has still to negotiate the percentage of reimbursement and the reimbursement price with the Economic Committee for Healthcare Products, along with the public health insurance. But fortunately enough, this negotiation takes place at same meetings. And the Economic Committee for Healthcare Products depends of the Ministry for Health. Then, after this negotiation, the registration of the product, its price, and its percentage of reimbursement is the subject of an order issued by the Ministry for Health. This process, of course, is a long process, but once registered, this registration is valid for 5 years. Now, in practice, the price difference between the biological product and the corresponding biosimilar is of 20-30%, whereas the average difference between originators and generics is around 40%. There is one thing to be noted as far as France is concerned, is that the French market has yet to develop further. It is far behind, for example, the German market. The penetration rate remains very low compared to the situation in other European countries. So now let us explore the situation in the Netherlands with Wim.
Thank you very much, Evelyn. The wholesale purchase prices, so the pharmacy purchase prices of medicinal products, including biosimilars, are regulated by the Dutch Medicines Prices Act. The Dutch Ministry of Health, Welfare and Sport fixes a maximum wholesale price for all prescription-only medicines, and these prices are listed in an annex to the Act. The procedure that is used by the Ministry of Health to establish the maximum wholesale price is external price referencing. And this means that the prices are fixed at the average wholesale price of similar medicines in Belgium, France, the UK, and Germany. In this case, a similar medicine is a medicine with the same active ingredient, the same strength, and the same pharmaceutical form. In this context, an originator, biological, and biosimilar may be qualified as similar medicines. There is a bill pending, in the House of Representatives with the goal to lower the prices of medicines. The present list of 4 reference countries will therefore be expanded, with Denmark, Finland, Ireland, Norway, Austria, and Sweden, and creating a total of 10 reference countries. In addition, the maximum wholesale price will be fixed at the average wholesale price of the 3 countries with the lowest prices for similar medicines. Maximum prices are revised every 6 months, taking into account changes in the prices of medicines in the reference countries and fluctuations, of course, in the exchange rate of the euro and the British pound. I'll go to my next slide. With respect to reimbursement, the Netherlands has a public health insurance system, and all residents in the Netherlands are required to take out a basic Dutch public health insurance package. Residents are free whether or not to take out any additional insurance coverage. Health insurance companies have to offer the same basic package to everyone and must accept all applicants regardless of age or state of health. The additional insurance packages can, however, differ and do in fact differ between health insurance companies. The health insurance coverage is decided upon by the Dutch Ministry of Health each year. And the ministry also decides which drugs fall under the basic health insurance package and are to be included in the medicines reimbursement system. And authorized medicines are assessed by the Healthcare Institute before they can be included in the medicines reimbursement system. For biosimilars, there, however, is a shortened procedure as they are not assessed by the Healthcare Insurance Board. Once a medicinal product is included in the medicine reimbursement system, it is fully or partially reimbursed depending on the type of product. Therapeutically interchangeable products are reimbursed according to the so-called reference price system and with limits in the reimbursed amounts. And unique products are reimbursed without a maximum. Biosimilars fall within the category of therapeutical interchangeable products. And medicinal products which are not included in the medicine's reimbursement system may also be reimbursed, but only in extreme and urgent circumstances. My next slide deals with the reference price system. So what is this reference price system in accordance with which therapeutically interchangeable products, including biosimilars, are reimbursed? All interchangeable medicines are clustered into groups. Medicines are considered interchangeable and are clustered in a group if they are used for the same indications, have the same pharmaceutical form, and are used for patients in the same age category. In addition, there should be no clinically relevant differences in their product characteristics. The reference price, or the maximum reimbursement price for a medicine in a cluster, is calculated based on the pharmacy retail prices of all medicines in a certain cluster. The reference price is fixed at a price equal to or directly below the average of the pharmacy retail prices of all medicines in the group. Medicines with a pharmacy retail price above the reference price are only partially reimbursed, and the patient has therefore to pay the difference between the reference price and the pharmacy retail price. With respect to the preference policy, to make things even more complicated, there is a preference policy in the Netherlands. Pursuant to this policy, a health insurance company can fix one or a limited number of products per product category or medicine cluster as preferred medicine for a fixed period. Patients insured with that company are then entitled to reimbursement of only that preference medicine. So the Ministry of Health still decides whether a medicine is eligible for reimbursement or not by means of including a product in a cluster in the medical reimbursement system. But the health insurance companies may further narrow the range of the reimbursed medicines within each cluster. And the goal of this policy is obviously more price competition and lower prices. There's, however, one legal exception. If there is a medical need for a non-preference medicine, the insurance company must reimburse that product. I'm handing over now to our U.S. colleagues of Willkie Farr.
Thank you, Wim. Appreciate it. This is Mike Johnson from Willkie Farr, and we're going to begin talking about the U.S. system, which to those of us in the U.S. will recognize immediately is very different than sort of the setups that we've been hearing about throughout the European countries. There's much less structure to it and much more private entities involved than government players. So what we were starting with here is sort of a high-level overview of the U.S. system and the players involved in it, because it is a very complicated framework in terms of pricing and reimbursement. After a brief introduction to the framework, we're going to talk about some of the competition issues and access issues that have been occurring with biosimilars in the United States. So to start with the players, obviously the first player is the biologic drug company, or the biosimilars. They're responsible for manufacturing and selling the drugs. And perhaps more interesting here is they negotiate normally with wholesalers or sometimes with large hospital systems, large pharmacies, or PBMs, pharmaceutical benefit managers. They negotiate to sell the drugs to them. For wholesalers, there's something that we'll talk about later of the wholesale acquisition cost. This is basically the cost negotiated, the average cost negotiated with wholesalers. But for purposes of this, it will become important, doesn't include any rebates or other discounts, which is a significant part of the U.S. system, as we'll see. They also will negotiate rebates with payers, the payers being primarily the insurance companies, whether that insurance is private insurance or insurance through the government in terms of Medicare or Medicaid. The second major player in the U.S. system is the wholesaler or distributor. Oftentimes they are key to the process in that they negotiate with the manufacturers and downstream with the ultimate users, often is the case. So they buy from the manufacturers and they sell to the treatment providers at a negotiated price that is often referred to as the AWP, or the average wholesale price. And what's interesting about the pricing system, that there's a whole lot of acronyms, and we're not even going to begin to touch on all of them. We're just going to highlight a few, basically to foster our understanding of the competition discussion that will be coming up next. The next group of players are the medical care providers themselves. This can be hospitals, outpatient clinics, oncology clinics, dialysis centers, doctor offices, or pharmacies in the case of sort of regular prescriptions. Many of the biosimilars today, all of the biosimilars that are marketed today, and many of the biologic medicines themselves, due to their nature, are often more of the sort that are administered either in a doctor's office or in some type of under the care of a medical provider in an oncology clinic or a dialysis center. There aren't quite as many where you go to the pharmacy, pick it up, and administer it. The patient administers to itself. But so we're primarily going to focus on that route for today's discussion through a medical provider. Now, of course, there's the patients who receive the treatment and pay both the insurers, the payers, premiums and the like to be part of the plan, but also in most cases, nearly all cases, they pay some sort of copay at the time that either the drug is administered or they pick up from the pharmacies. And then finally, the driver in many ways of most of the pricing in the United States are what we call the payers. And there's many different sort of realms and regimes of payers. There's private insurance companies that are either contracted through your employers, through labor unions, through all sorts of sources, including privately by individuals. There's the U.S. government, this through their Medicare, which is basically health insurance for older individuals, and Medicaid, which is health insurance for poorer people or people out of a job, basically. They cover a lot of people. And then there's uninsured patients who present another issue for the system. And the way the U.S. government Medicare system dictates, they have two different coverage elements, and private insurance largely follows a similar type setup. The Part B system of Medicare, as it's referred to in the United States, deals with drugs that are administered essentially by a doctor or a healthcare professional, those in the hospital, in the doctor's office, in the clinics. Part D is Part B is sometimes referred to as the medical benefits portion of Medicare. Then Part D of Medicare is often referred to as the prescription drug benefit. These are, drugs that you pick up at the pharmacy, or more and more now through mail order pharmacies in the United States, and the patient would self-administer those. For purposes of today's discussion, because all of the approved biosimilars to date fall under Part B, and most of the biosimilars approved actually fall under, most of the biologics that are currently being marketed fall under Part D. We're going to focus on that. So we've generated a chart here on the next slide that basically summarizes an overview the players here and how they interact. You see at the top are the drug companies themselves. They interact with the wholesalers by providing drugs at the WAC, the wholesale acquisition cost. They also negotiate rebates, as we'll hear a lot about in the competition section. These rebates often go to payers or this other entity, that pharmaceutical benefit managers. Now, the PBMs are an agency that essentially contracts with the payers to manage the prescription drug benefits. It's more of a prescription drug benefit issue, so we didn't focus on that. But they're a big part of the prescription system. These rebates are often based on the volume or even the exclusivity of the drugs, or their placement on the formularies. The payers, either through themselves or the PBMs, often have formularies where the drugs there's different co-pays, for example, for the patients when a drug is on a different formulary. Sometimes when you're on a different formulary, you may need to get specific authorization and the like. So that is a huge driver of what is prescribed in the United States. And then the wholesalers obviously interact with the medical providers for what we refer to as the average wholesale price, and then deal with the payers in terms of reimbursement. How much money are they going to get from the insurance companies? The patients receive and pay insurance policies, and actually there should be an arrow going back up in the copay for the medical providers as well. But that's sort of a cartoon indication, probably a greatly oversimplified version of the reimbursement and pricing schedule in the United States. The effect of this is it's often very difficult to find out what the actual pricing is for a drug. The list price is almost never the ultimate price of the drug. The price of the drug, quote-unquote, price of the drug varies on all sorts of things, including the wholesale acquisition cost, which doesn't factor in rebates, reimbursements. The average sales price is a term you hear batted about, is a calculated weighted average of the manufacturer's sales price, subtracting out rebates and discounts and reimbursements that are provided either to the insurer, provided primarily to the insurers. So what we've done is we've looked at some of the pricing so far, and I think those of you who have been on our previous webinars will recognize this slide. It talks about the approved biosimilars in the United States, and you'll notice that of all these approved, there's only 5 of them that are currently being marketed. And that's actually an update from earlier, because the one on the very bottom, Pfizer's biosimilar to Neupogen, was just approved in the last week or two. So obviously we don't have much data on that one yet. But what does the pricing of biosimilars look like so far in the United States? Generally, we've seen sort of a 15 to 30% reduction. I think it's trending lower. I think the first biosimilars that came out were closer to the 10 to 15% range, which, as we've talked about previously, did generate a whole lot of market penetration, and now we're seeing some greater discounts by the biosimilar manufacturers to generate and drive that market penetration. And you see some examples of the different average sales price, which of course comes with some limitations as to what significance that really has. So with that overview of the system and the pricing and the reimbursements, I'm now going to turn it over to my partner, Heather Schneider, to talk about some of the implications and competition issues that have come out of this rather complicated system.
Thank you, Mike. And one thing I want to note before going to the substance is, for those of you who are on the webinar and would like to get U.S. CLE credit, we're offering credit in New York, California, and Illinois, and you can always email us about another state. The code that you'll need to enter in the form is WFNG 1315, WFG 1315. That's 1315 is this webinar's code. And if anyone has questions afterwards, you can contact us and we can help facilitate your CLE credit. So, following on everything Mike said about, the sort of complicated structures in the United States, what are some of the market access issues that are facing biosimilars? First of all, the pricing of biosimilars typically reflects the high manufacturing complexity and the increased regulatory barrier faced by biosimilars compared to small molecule drugs. I mean, basically compared with generics, biosimilars require a significant upfront investment. And in particular, as we've previously discussed, there haven't been any biosimilars given the interchangeable designation. The pricing may reflect the need of biosimilar manufacturers to advertise and detail their drugs. I think a lot of people familiar with the Hatch-Waxman Act for generic drugs in the United States are used to the fact that generic drugs would primarily be automatically substituted and companies didn't really have to advertise their generic drugs. That is going to be different in the realm of biosimilars. That will be one reason the cost might be higher. There have been issues in the United States, just sort of some reluctance by physicians and patients to switch to biosimilars. And this is one of the factors that the FDA is trying to address in its FDA action plan that Mike spoke about at our last webinar to try to educate the public about the benefits of biosimilars. And then the last topic that's really going to address the rest of our presentation from the U.S. side are alleged actions of reference product sponsors. When does a company say that the sort of brand name biologic manufacturer has done something anti-competitive to prevent competition? So there's an interesting test case going on in the United States. It's an antitrust case brought by Pfizer against Johnson & Johnson. This case was brought in September 2017, a little over a year ago. And Pfizer filed this suit against J&J. J&J is the seller of Remicade, the reference product for infliximab. And Pfizer alleges that it got approval for its Inflectra infliximab biosimilar and began shipping it in November 2016. That was about 2 years ago. And Pfizer says it was charging a lower price than Remicade. And as Mike mentioned, price in the United States can be a little bit of a fuzzy area, so one of the debates is whether or not Pfizer's price really was lower. But Pfizer alleged that it was. And in response to the launching of a biosimilar, J&J began implementing what it called its biosimilar readiness plan. And J&J basically said it was implementing contracts that bundle rebates on Remicade, as well as some of J&J's other top-selling drugs, in return for promises not to reimburse for biosimilars. And Pfizer says that as a result of this plan, a very targeted plan, Pfizer says, to prevent biosimilar competition, Pfizer's Inflectra drug has been foreclosed from competing for 70% of privately insured patients. And as I go through the next slides, I'll understand why it is that this could affect such a large portion of patients. And so according to Pfizer, as of September 1st, 2017, 90% of healthcare providers using infliximab had not purchased any Inflectra at all. And so the question that arises is, well, if Pfizer really is charging a lower price for Inflectra, why isn't it gaining any traction with consumers? And to sort of understand what's going on, I made some edits to Mike's chart to say what is the alleged issue in this Pfizer case. So as Mike mentioned, the drugs we're dealing with right now are part of the medical benefits. They're provided by medical providers. They're not something you pick up at your local pharmacy. And so what happens in the United States is medical providers will buy the drug and then depend on getting reimbursed later. So they'll have, Remicade or Inflectra on hand to give patients, and then they depend on getting reimbursed. So the medical providers are bearing the risk of reimbursement. So what's happened really Pfizer's complaint focuses on the relationship between the drug companies, J&J in this case, and the payers, primarily the large private insurance companies. And basically what Pfizer said is that J&J implemented what they're calling a rebate trap, or what Pfizer calls a rebate trap, where basically J&J would give such significant rebates on Remicade, but only under certain conditions. One was that J&J would bundle Remicade with some of its other biologic products, Simponi and Simponi Aria and Stelara, so that you would get a lower price on the whole suite of products if you would exclude biosimilars of Remicade. Pfizer also alleged that J&J would sort of bundle rebates between existing Remicade patients and new patients. Pfizer said that J&J took an all-or-nothing approach. If you want to get and keep the discount on Remicade for your existing patients, you need to make sure all your new patients get Remicade as well. Coupled with this, Pfizer said that J&J entered exclusive contracts, some of which very explicitly said you have to be exclusive with us and you cannot reimburse biosimilars. Other contracts had a provision referred to as fail first, saying that you could reimburse someone for using a biosimilar, but only if Remicade failed first. And Pfizer pointed out that that was somewhat ludicrous, because if Remicade failed for a patient, what are the odds that a biosimilar to Remicade would work? And so that was really an option in sort of name only. So basically, Pfizer is complaining that even though its price for its drug is lower, because of all these rebates, it can't break into the market. And Pfizer alleged that, in fact, J&J has been increasing the list price, the price that Mike mentioned that hardly anyone pays, ever since Pfizer's competing product came on the market. So that actually there's a list price increase coupled with these rebates that are harming consumers and keeping Pfizer out of the market. So in its actual complaint, that Pfizer filed in court, they alleged 4 particular violations of different aspects of U.S. antitrust law: monopolization, attempted monopolization, exclusionary contracts, and agreements in restrictive trade. And in addition to Pfizer's complaint, there have actually been class action complaints filed as well by some of the purchasers and some of the other players in the market that Mike referred to. Now, J&J, of course, came back with some defenses and said, look, this is just good old competition. Pfizer is just saying it's been harmed. Competition isn't harmed. And in fact, how can offering rebates be a bad thing? And in fact, J&J said that Pfizer hasn't shown that it properly attempted to compete. Pfizer is a big company, and it should have provided its own multi-product bundles and rebates as well. And basically, J&J said, look, you're really just complaining about us charging lower prices. And that's very rarely an antitrust issue. It's typically only an antitrust issue under U.S. law if you engage in what's called predatory pricing, where you actually price below cost for a period of time such that you can exclude competitors in the market, and then when your competition is gone, increase your price to recoup it. So those were the defenses that Johnson & Johnson brought in a motion to dismiss. The court, at least at this time, has denied the motion to dismiss, and it was just denied 2 months ago on August 10th, 2018. Now, the court's decision is interesting. It's just at the motion to dismiss phase, so it's generally taking Pfizer's allegations as true. The court did not seem as concerned about the multi-product bundling on its own. The court basically said that Pfizer is not a single product producer and that it hasn't alleged facts sufficient to show that that J&J was hindering Pfizer's ability to offer their own multi-product bundles. So on its own, the court wasn't concerned about that. However, the court was concerned about this bundling of sort of new and existing Remicade patients. The court found that this could fall into a traditional bundling area, which can be anti-competitive, because it's basically preventing competition for those new patients who are not on Remicade yet and are still in a position to make a choice about what drug they will get. And so the court refused to dismiss that complaint. And really, the court summed it up well at the end of the decision. Ultimately, The legality of J&J's conduct will depend on whether it foreclosed a substantial share of the market such that competition has been harmed. So since this motion to dismiss was denied, this means that the case, as well as all the class action suits, are moving forward to discovery. Discovery in U.S. antitrust cases tends to be a long and expensive process that will certainly involve a lot of economic experts debating the structure of the market and all these various prices that we've discussed. So we'll all watch that, and with that, I will hand it back over to our European colleagues to wrap up on competition in the EU.
Thank you very much. This is Wim from the Netherlands again. I'm going to our next slide, and I'm going to talk about, see whether this works. Yeah, it does. I'm going to a slide and talk about competition issues in the Netherlands. The Dutch Competition Authority already dealt with pricing policies of pharmaceutical companies once in the AstraZeneca case, which was decided in 2014. AstraZeneca produced Nexium, a gastric acid suppressant, and had acquired patent protection for it. I was able to prevent the entry of generics onto the market for the period of time of 2001 to 2010. AstraZeneca offered large discounts to hospitals, the main initial prescribers of these kind of drugs, but also to the entity paying for the drugs in a sense. As most general practitioners had a tendency to keep prescribing Nexium for patients who came out of the hospital, the majority of the patients using Nexium inside the hospital would continue to do so outside the hospital walls. In the extramural context, the choice of the drug was made by the patient and or its doctor, whilst the drug itself is paid by the healthcare insurers, who had no alternative because at the time the insurers were obligated to compensate the specific medicine elected by the Ministry of Health. The extramural price of Nexium was significantly higher than the intramural price, and the competition authority in the Netherlands investigated whether this price difference applied by AstraZeneca entailed abuse of a dominant position. Although it could not be ruled out by the Dutch Competition Authority that AstraZeneca had intentionally profited from the interaction between the intramural and extramural market, the so-called emanation effect, in the end, the authority could not establish decisively a dominant position of AstraZeneca on either the intramural or the extramural market, and therefore did not find an infringement of antitrust rules under the Dutch Competition Act. And I'm going to talk a little bit about the current trends in the Netherlands in the near future. Although the Competition Authority failed to enforce competition law in the pharmaceutical sector in the past, that may soon change, it's our prediction. On its agenda for 2018 and 2019, the Competition Authority in the Netherlands has elected the price of medicines as one of its key priorities. That means, and it already has been seen on the market, that they launched sector inquiry into the prices of TNF inhibitors, which are drugs used to combat rheumatism. Also, the Competition Authority has been requested to enforce the Competition Act by a Dutch association called Holding Pharma Accountable. And this Dutch association, the request of this association pertains to the drugs Chinofalk. I don't know whether I'm pronouncing it correctly, but Chinofalk used to treat the rare metabolic disorder CTX. When the rights to Chinofalk were acquired by Lydian, and after it acquired orphan drug status for Chinofalk, the price of the drugs became 500 times higher than before. This is now being researched by the Dutch Competition Authority. with respect to some European case law, with regard to competition law question related to product launches, the Dutch Competition Authority might also be able to draw inspiration from the recent and less recent case law of the European Court of Justice in the pharmaceutical sector. The ECJ has on numerous occasions ruled on the question when pharmaceutical manufacturers, both originators and generics, might be considered competitors of one another, downplaying the effectiveness and the exaggerated side effects of cheaper drugs for tumors that proved to also be effective for the treatment of retinal diseases was deemed anti-competitive by the ECJ and the Hoffman, the old but famous Hoffman-La Roche case. Even though a certain drug is initially intended for tumors and lacks a specific marketing permit for the treatment of retinal diseases, it might still be a competing product that forms part of the same product market, the treatment of the latter disease. The Lundbeck case and the AstraZeneca case of the ECJ confirm that the term actual or potential competitor has a broader scope in the pharmaceutical sector than in other sectors. That is to say, the time before market entry of party A can be longer than 1 or 2 years, but company A might still be considered a competitor of party B who is already present on the market. So to wrap it up, there is a lot of attention in the Netherlands and also based on past cases of the European Court of Justice, which is focusing now on the pharmaceutical market. I'm handing over now to Matt, and I'm going to the slide he's discussing. Is this the slide? I think it is. Matt?
Yeah, thanks very much, Wim. I think what will be clear from Wim's comments is that sort of challenges based on the behaviours of companies in the market can and sort of most likely will lead to competition challenges in Europe, as well as we've sort of heard Heather and Mike discuss in the US. At present, we haven't seen any such challenges in relation to biosimilar products. However, competition challenges are something that litigants in relation to biosimilars are well aware of and have been using, albeit in a different context. In the litigation in relation to adalimumab between Fujifilm and AbbVie, a complaint was made to the European Commission. This was not in relation to market behaviours, but instead in relation to AbbVie's patent prosecution behaviour. As one would expect of a product as large as Humira, AbbVie had a large patent portfolio covering a number of aspects and medical uses of the Humira product. There is, of course, nothing unusual or wrong about that. However, what AbbVie were doing was filing divisional applications and then allowing the granted parent patents to lapse or simply not defending them. What drew particular criticism from the judge in this case, and may have led to the competition complaint being filed, was AbbVie's decision to de-designate the UK. In his judgment, Mr. Justice Henry Carr said that AbbVie has abandoned all relevant UK patent protection in order to avoid scrutiny by the UK court and to prolong commercial uncertainty as to the validity of those patents. During the course of the litigation, it was disclosed by one of the parties during submissions to the court that a complaint had been filed at the competition authorities about AbbVie's behaviour. We don't have any details about the complaint, which will actually not be public until the Commission makes a decision on whether or not to open a formal investigation. But it's likely that AbbVie is alleged to have been abusing its dominant position. What will be happening now behind the scenes is that the Commission will be investigating the complaint. This process can take several years before a decision is made on whether or not to start a formal investigation, and there is no news as yet. What this example shows is that, as in the US, the size of the biologics market are such that litigants will use any and all means available to them, and this includes filing competition complaints. It will not therefore be surprising if we see cases of the nature described by Heather and Mike in Europe over the coming years. That concludes this webinar and our series of webinars focusing on biosimilars. It remains for me to thank our speakers, Manya Epping, Evelyn Friedel, Wim Maas, Heather Schneider and Mike Johnson, and to thank you for attending our webinar series. Necessarily, we have not been able to cover every nuance of biosimilars, their authorization and route to market during our webinars. And so, if you do have any questions arising out of anything we said on a webinar or about biosimilars generally, please reach out to one of us and we'd be very happy to help. Finally, thank you for joining today's webinar. Could I ask you to hold on for a few moments to answer a short feedback form?